The landscape of travel to and within the United States in 2025 has become an intricate web of regulations, with several new restrictions and policy shifts taking even the most seasoned travelers by surprise. While some foundational changes, like the long-anticipated Real ID enforcement, have received considerable public attention, many other significant updates have emerged more subtly, catching countless individuals, both US citizens and foreign nationals, entirely off guard. These unexpected bans and tightened regulations are far from minor inconveniences. They can result in severe consequences, including denied boarding, abrupt visa revocations, and even immediate deportation. Understanding these nuanced, often silently implemented shifts is no longer merely advisable, but absolutely crucial for anyone planning to navigate the complex American travel ecosystem in the current year. The days of casual, unresearched travel are definitively over. Here are 8 unexpected US travel bans and significant restrictions you might not have seen coming in 2025, detailing their origins, impacts, and how best to prepare for them. 1. The Real ID enforcement for domestic air travel, May 7, 2025. The unexpected twist. For nearly 2 decades, the specter of Real ID enforcement has loomed, often with projected deadlines pushed back, fostering a pervasive sense among the public that it will never really happen. This complacency led many travelers to anticipate yet another deferral or at least a forgiving grace period beyond the official date. However, May 7, 2025 has arrived with a hard deadline for using a Real ID compliant driver's license or state ID for domestic flights. And critically, there has been no widespread lenient grace period. This unyielding enforcement has indeed caught a substantial segment of the US populace completely unprepared. Many simply assumed their existing non-compliant driver's license would continue to be accepted indefinitely, or they gravely underestimated the administrative process and potential wait times involved in obtaining a Real ID from their state's Department of Motor Vehicles, DMV. The sheer volume of non-compliant IDs still in circulation is a testament to this collective oversight. Impact: for US citizens aged 18 and older, attempting to board a domestic flight within the United States with a driver's license or state ID that is not Real ID compliant, i.e., lacks the distinctive star symbol typically found on the upper right corner, will result in an absolute denial of boarding. This effectively functions as an internal domestic travel ban for individuals lacking an acceptable alternative form of identification, which includes a valid US passport, a US passport card, or a military ID. What's particularly unexpected for many is that even members of expedited screening programs like TSA PreCheck are not exempt from this fundamental identity verification rule. How to avoid: immediate action is required. Verify your driver's license for the star symbol. If it's absent, visit your state's DMV website today to understand the specific documentation required to obtain a Real ID, usually proof of identity, residency, and social security number. Begin the application process as soon as possible, as appointments and processing times can vary. If you cannot obtain a Real ID before your flight, ensure you have a valid US passport or another acceptable federal ID ready for presentation at the airport. 2. Termination of key humanitarian parole programs. The unexpected twist. Throughout recent years, various humanitarian parole programs had served as vital pathways for individuals from specific countries grappling with severe political, economic, or environmental crises to legally enter the United States. These programs, while temporary, offered a crucial lifeline. However, 2025 has witnessed their abrupt termination or significant pausing, leading to widespread disbelief and despair. Most notably, the processes for Cubans, Haitians, Nicaraguans, and Venezuelans, CHNV, programs stopped accepting new applications in January 2025. The truly unexpected and devastating blow for many existing beneficiaries of this program was the Supreme Court's definitive ruling on May 30, 2025, upholding the government's ability to terminate the humanitarian parole status for existing CHNV arrivals. This ruling has plunged thousands into legal limbo, making them immediately vulnerable to deportation unless they had already managed to secure an alternative, more permanent legal status, such as asylum or temporary protected status, TPS. Adding to this, the Uniting for Ukraine, U4U, program also saw a suspension of new applications and all federal contracts for the U.S. Refugee Admissions Program, USRAP, which included the Welcome Cause initiative that allowed private sponsors to facilitate refugee resettlement, were definitively terminated in late February 2025. Impact: these sweeping changes constitute a direct, albeit quiet, travel ban for potentially hundreds of thousands of individuals who are either seeking humanitarian protection or hoping to be reunited with family in the US through these government-sanctioned avenues. For those already in the US under parole, the Supreme Court's decision creates immense uncertainty, fear of immediate arrest, and potentially irreversible separation from family members. This policy shift reflects a significantly hardened stance on immigration and refugee intake, prioritizing strict border control over humanitarian considerations. The suddenness and finality of these terminations, particularly the judicial endorsement, were highly unexpected for many international aid organizations, immigration advocacy groups, and the affected communities themselves, illustrating a rapid policy pivot. How to avoid mitigate. For those impacted or with family members potentially affected, immediate legal counsel specializing in immigration law is paramount. Explore all possible avenues for securing alternative legal status, e.g. asylum claims, family-based petitions, as quickly as possible. For those still hoping to enter the US for humanitarian reasons, research other, more limited visa options or alternative entry programs that may arise, though options are currently highly restricted. 3. Broadened criteria for visa revocations, especially for Chinese students. The unexpected twist. While the US government has always reserved the right to revoke visas, 2025 has seen an alarmingly broad expansion of the criteria used for such actions, disproportionately impacting Chinese students and scholars. A highly controversial statement from the US State Department in late May 2025 indicated that visas for Chinese students with nebulous connections to the Chinese Communist Party, CCP, or those studying in critical fields, defined with increasing ambiguity, would be subject to immediate revocation. The truly unexpected and deeply troubling aspect here is the deliberate vagueness surrounding terms like connections and critical fields, making it virtually impossible for individuals to definitively ascertain their vulnerability. Furthermore, there are widespread reports of mass student visa revocations based on even minor, previously overlooked infractions, such as old speeding tickets or seemingly innocuous past associations, suggesting a much broader and more aggressive tightening of visa policies than publicly declared. Impact. This constitutes a significant, often covert, ban or immediate expulsion for thousands of affected Chinese students and researchers, disrupting their academic pursuits, professional careers, and established lives in the US. It cultivates an atmosphere of profound uncertainty and pervasive fear within the international student community, particularly among Chinese nationals, as individuals who believed their visas were secure could suddenly find them revoked without clear justification or due process. This aggressive shift reflects heightened national security concerns, a more confrontational stance on foreign influence within American academic and research institutions, and a willingness to extend vetting criteria far beyond previously defined parameters, effectively creating a barrier to entry for a specific demographic. How to avoid mitigate. For current or prospective international students, especially those from China, it is crucial to consult with experienced immigration attorneys regarding their specific situation. Maintain impeccable records of academic performance and conduct. Be extremely cautious about social media activity and any past associations, understanding that US authorities may apply broad interpretations. Ensure full transparency in all visa applications and renewals. 4. New alien registration requirement and mandatory carrying of proof. The unexpected twist. In a significant yet largely unpublicized expansion of immigration control, an Executive Order 13159, ominously titled Protecting the American People Against Invasion, first implemented in January 2025 and subsequently solidified by an interim final rule taking effect on April 11, 2025, introduced a new, comprehensive alien registration requirement. This mandate stipulates that all foreign nationals aged 14 or older who were not fingerprinted upon their initial visa application, a common scenario for many visitors, and who remain in the US for 30 days or longer must now undergo a mandatory online registration process, Form G325R, and be fingerprinted at a designated location. The truly unexpected and critical element, however, is the added stipulation that all foreign nationals aged 18 or older must at all times carry proof of this completed registration. Impact. This regulation acts as a de facto ban or significant legal snare for foreign nationals who, unknowingly or through oversight, fail to comply. Failure to register or, crucially, failure to carry visible proof of this registration, e.g. a printed confirmation or a digital record, can lead to severe criminal and civil penalties. These can range from misdemeanor prosecution and hefty fines to detention and ultimately deportation. This constitutes a substantial new legal requirement that many foreign visitors, even those on perfectly valid visas for tourism, business, or education, might be entirely unaware of, inadvertently turning a seemingly innocuous administrative step into a potential legal trap. It fundamentally alters the experience of being a foreign national in the US, adding a pervasive layer of constant vigilance and the risk of unexpected legal challenges. How to avoid. All foreign nationals entering the US should immediately check if this new registration requirement applies to them based on their visa type and duration of stay. If it does, ensure the online registration is completed promptly upon arrival. Crucially, obtain and carry physical or digital proof of this registration at all times, alongside your passport and visa. It is advisable to consult with an immigration lawyer if unsure about the specific requirements. 5. Heightened scrutiny for lawful permanent residents, green card holders. Abroad. The unexpected twist: lawful permanent residents, LPRs, commonly known as green card holders, have always understood that extended periods outside the US could jeopardize their residency status. However, 2025 has seen an unprecedented and notable increase in scrutiny applied at US ports of entry, particularly for those LPRs who have spent more than 6 months consecutively outside the country. The truly unexpected aspect is the intensity and depth of questioning at these checkpoints, coupled with a dramatically heightened likelihood of being referred to an immigration judge for those who have been absent for 12 months or longer without having first obtained a re-entry permit. This signals a significantly stricter interpretation of abandonment of residence than observed in previous years, placing a much heavier burden of proof on returning LPRs. Impact: this amplified scrutiny functions as a soft travel ban, effectively discouraging many green card holders from undertaking extended stays abroad due to the pervasive fear of losing their hard-earned residency. It compels them to actively maintain more stringent, demonstrable ties to the US, e.g. gold, property, employment, family, and to be meticulously prepared for intense, detailed interrogation upon re-entry. This subtle but impactful policy shift demonstrably restricts the freedom of movement for LPRs more than in previous decades, subtly pushing them towards more continuous US presence. The underlying message is that the privilege of permanent residency comes with a heightened expectation of continuous physical presence and integration. How to avoid, mitigate: LPRs should meticulously track their time outside the US. If planning to be abroad for more than 6 months but less than a year, gather extensive documentation proving your intent to return, e.g. property leases, employment letters, family ties, US tax returns. For stays exceeding 1 year, it is imperative to apply for a re-entry permit, Form 1, 1 and 31, before departing the US. This permit typically allows for absences of up to 2 years without jeopardizing LPR status. Always be honest and thorough when questioned by Customs and Border Protection officers. 6. Implicit travel restrictions, based on social media monitoring. The unexpected twist: the concept of governments monitoring social media is not new, but 2025 has seen the confirmed implementation of a highly controversial catch and revoke program, reportedly employing advanced artificial intelligence (AI) to actively review the social media presence of visa holders. The aim is to identify and target individuals linked to certain protests, political activities, or online content deemed concerning or potentially subversive by US government agencies. While explicit, publicly announced travel bans based solely on social media posts are rare, the active, automated monitoring and subsequent quiet visa revocations constitute a less transparent yet highly effective form of travel restriction. Impact: this surveillance creates an insidious and pervasive form of ban where foreign nationals might find their valid visas abruptly revoked without clear, transparent justification. This can occur based on online activities that, in many other contexts, might be considered protected speech or innocuous personal opinions. The unexpected nature lies in the hidden automated surveillance mechanisms and the ambiguous, shifting criteria used to flag and revoke visas, turning digital interactions into potential tripwires for travel. How to avoid/mitigate: exercise extreme caution regarding all online activity. Assume that all your public social media posts, comments, and interactions are subject to review. Avoid engaging with or sharing content that could be misconstrued as supporting extremist ideologies, illegal activities, or anything that could be interpreted as a threat to US national security or public order. Be mindful of your likes, follows as well. Consider limiting public-facing social media, making profiles private if your travel plans are critical. 7. New unofficial travel advisories and implicit discouragement. The unexpected twist: beyond the well-known and often dire Level 4 do not travel advisories, typically reserved for war zones or extremely unstable regions like Russia, Somalia, or Syria, 2025 has seen a significant increase in the issuance of more nuanced, subtly impactful travel advisories for countries traditionally considered safe and stable. These advisories often focus on an elevated level of caution due to factors like increased petty crime or a general heightened risk of terrorist violence, even if the overall State Department advisory level for these nations remains relatively low, e.g. Level 2, exercise increased caution. For instance, specific detailed advisories for popular European destinations like France and Belgium were updated in late May 2025, emphasizing pickpocketing hotspots or broad terrorist risk, without necessarily changing the overall country warning level. This heightened level of granular detail, sometimes highlighting what might seem like everyday risks in major cities, is designed to implicitly discourage travel for risk-averse individuals. Impact: while not a formal government ban, these intensified advisories can lead to a de facto reduction in travel from the US to the named destinations. They can influence travel insurance validity. Some policies may not cover incidents if advisories are in place, affect decisions by tour operators and cruise lines, and significantly impact individual comfort levels, subtly guiding traveler choices away from certain regions without any explicit prohibition. The unexpected element for many travelers is this refined strategy of soft deterrence, the detailed emphasis on specific, seemingly minor or generalized risks in traditionally safe, popular European destinations, which collectively aims to shift travel patterns without a direct policy change. How to avoid mitigate. Always check the US State Department's travel advisories, travel.state.gov, immediately before booking and again before departure. Pay close attention, not just to the overall level, but to the specific reasons to exercise increased caution listed for your destination. Understand how these advisories might affect your travel insurance. Consider these detailed warnings as subtle cues to exercise heightened vigilance and perhaps adjust your itinerary or personal security precautions. 8. Potential airline carry-on size reductions and increased baggage fees. The unexpected twist. While not a direct government-imposed travel ban, significant US airlines, including major players like American Airlines, Delta, and WestJet, a key Canadian airline with extensive US routes, are confirmed or strongly rumored to be implementing substantial updates to their baggage policies in 2025. This move is partly influenced by a push towards more uniform, stricter European carry-on standards and airlines' desire to increase ancillary revenue. The unexpected part for many travelers is the possibility of their existing standard carry-on bags suddenly becoming non-compliant. Impact. This policy shift could act as a de facto ban on current, slightly larger carry-on bags that a vast number of travelers are accustomed to using. Passengers with bags exceeding the new, smaller dimensions would be forced to check them, almost certainly incurring additional baggage fees. For budget-conscious travelers and those who rely heavily on carrying on to save money, avoid checked baggage delays, or simply keep essential items close, this represents a significant and unwelcome restriction. It effectively pushes more passengers towards paid, checked baggage services, thereby increasing the overall cost and complexity of air travel for those unprepared for the physical dimension reductions. How to avoid. Before every flight, check your specific airline's current baggage policy, paying close attention to both carry-on and personal item dimensions, length, width, and depth. Do not rely on past experiences. If purchasing new luggage, invest in bags that adhere to the strictest international carry-on standards to ensure future compliance. Pack efficiently to maximize space within smaller dimensions, and be prepared to pay for checked baggage if your current carry-on exceeds the new limits. The landscape of US travel in 2025 is unequivocally more complex, more regulated, and significantly more unpredictable than in previous years. From evolving domestic ID requirements and a hardened stance on international entry pathways to subtle yet profoundly impactful policy changes, travelers must remain exceptionally vigilant. The unexpected nature of these bans and restrictions underscores the paramount need for continuous research, meticulous preparation, and an adaptable mindset to ensure a smooth and uninterrupted journey. Ignoring these evolving rules can lead to severe disruptions, outright denied entry, substantial financial penalties, or even legal repercussions, truly making certain US travel experiences an unwelcome and challenging prospect. Be informed, be prepared, and stay updated. The US travel landscape in 2025 demands unparalleled vigilance. From the hard deadline of Real ID to the nuanced impacts of visa revocations, new registration mandates, and stricter rules for green card holders, the era of casual travel is over. Unexpected restrictions, often subtle, highlight a shift towards heightened security and tighter control. Travelers must proactively research, meticulously prepare, and remain adaptable. Ignoring these evolving regulations risks denied boarding, significant delays, or even legal consequences. Your preparedness is the key to navigating this complex environment, ensuring a smooth, secure journey in a system that won't always warn you.